Now I will continue the reading of the judgment. SS. Structure and component parts. The prosecution has named Die Schutzstaffeln der Nationalsozialistischen Deutschen Arbeiterpartei, commonly known as the SS, as an organization which should be declared criminal. The portion of the indictment dealing with the SS also includes the Die Sicherheitsdienst des Reichsführer SS, commonly known as the SD. This latter organization, which was originally an intelligence branch of the SS, later became an important part of the organization of security police and SD, and is dealt with in the tribunal's judgment on the Gestapo. The SS was originally established by Hitler in 1925 as an elite section of the SA for political purposes, under the pretext of protecting speakers at public meetings of the Nazi Party. After the Nazis had obtained power, the SS was used to maintain order and control audiences at mass demonstrations, and was given the additional duty of internal security by a decree of the Führer. The SS played an important role at the time of the Rome Purge of June the 30th, 1934, and as a reward for its services, was made an independent unit of the Nazi Party shortly thereafter. In 1929, when Himmler was first appointed as Reichsführer, the SS consisted of 280 men who were regarded as especially trustworthy. In 1933, it was composed of 52,000 men, drawn from all walks of life. The original formation of the SS was the Allgemeine SS, which by 1939 had grown to a corps of 240,000 men, organized on military lines into divisions and regiments. During the war, its strength declined to well under 40,000. The SS originally contained two other formations. The SS Verfügungstruppe, a force consisting of SS members who volunteered for 4 years armed service in lieu of compulsory service with the army, and the SS Totenkopfverbände, special troops employed to guard concentration camps, which came under the control of the SS in 1934. The SS Verfügungstruppe was organized as an armed unit to be employed with the army in the event of mobilization. In the summer of 1939, the Verfügungstruppe was equipped as a motorized division to form the nucleus of the forces which came to be known in 1940 as the Waffen-SS. In that year, the Waffen-SS comprised 100,000 men, 56,000 coming from the Verfügungstruppe, and the rest from the Allgemeine SS and the Totenkopfverbände. At the end of the war, it is estimated to have consisted of about 580,000 men and 40 divisions. The Waffen-SS was under the tactical command of the army, but it was equipped and supplied through the administrative branches of the SS and under SS disciplinary control. The SS central organization had 12 main offices. The most important of these were the RSHA, which has already been discussed, the WVHA, or Economic Administration Main Office, which administered concentration camps along with its other duties, a Race and Settlement Office, together with auxiliary offices for repatriation of racial Germans, Volks, Deutsche Mittelsteller. The SS central organization also had a legal office, and the SS possessed its own legal system, and its personnel were under the jurisdiction of special courts. Also attached to the SS main offices was a research foundation known as the Experiments Annenerbe. The scientists attached to this organization are stated to have been mainly honorary members of the SS. During the war, an Institute for Military Scientific Research became attached to the Annenerbe, which conducted extensive experiments involving the use of living human beings. An employee of this institute was a certain Dr. Rascher, who conducted these experiments with the full knowledge of the Annenerbe which was subsidized and under the patronage of the Reichsführer SS, who was a trustee of the foundation. Beginning in 1933, there was a gradual but thorough amalgamation of the police and SS. In 1936, Himmler, the Reichsführer SS, became chief of the German police, with authority over the regular uniformed police as well as the security police. Himmler established a system under which higher SS and police leaders, appointed for each Wehrkreis, served as his personal representatives in coordinating the activities of the order police, security police, and SD, and Allgemeine SS within their jurisdictions. In 1939, the SS and police systems were coordinated by taking into the SS all officials of the security and order police at SS ranks equivalent to their rank in the police. Until 1940, the SS was an entirely voluntary organization. After the formation of the Waffen-SS in 1940, there was a gradually increasing number of conscripts into the Waffen-SS. It appears that about a third of the total number of people joining the Waffen-SS were conscripts, that the proportion of conscripts was higher at the end of the war than at the beginning, but that there continued to be a high proportion of volunteers until the end of the war. Criminal activities. SS units were active participants in the steps leading up to aggressive war. The Wehrführungstruppe was used in the occupation of the Sudetenland, of Bohemia and Moravia, and of Memel. The Henlein Free Corps was under the jurisdiction of the Reichsführer SS for operations in the Sudetenland in 1938, and the Volksdeutsche Mittelstelle financed fifth column activities there. The SS was even a more general participant in the commission of war crimes and crimes against humanity. Through its control over the organization of the police, particularly the security police and SD, the SS was involved in all the crimes which have been outlined in the section of this judgment dealing with the Gestapo and the SD. Other branches of the SS were equally involved in these criminal programs. There is evidence that the shooting of unarmed prisoners of war was the general practice in some Waffen-SS divisions. On October the 1st, 1944, the custody of prisoners of war and interned persons was transferred to Himmler, who in turn transferred prisoner of war affairs to SS Obergruppenführer Berger and to SS Obergruppenführer Pohl. The Race and Settlement Office of the SS, together with the Volksdeutsche Mittelstelle, were active in carrying out schemes for Germanization of occupied territories, according to the racial principles of the Nazi Party, and were involved in the deportation of Jews and other foreign nationals. Units of the Waffen-SS and Einsatzgruppen operating directly under the SS main office were used to carry out these plans. These units were also involved in the widespread murder and ill treatment of the civilian population of occupied territories. Under the guise of combating partisan units, units of the SS exterminated Jews and people deemed politically undesirable by the SS, and their reports record the execution of enormous numbers of persons. Waffen-SS divisions were responsible for many massacres and atrocities in occupied territories, such as the massacres at Oradour and Lidice. From 1934 onwards, the SS was responsible for the guarding and administration of concentration camps. The evidence leaves no doubt that the consistently brutal treatment of the inmates of concentration camps was carried out as a result of the general policy of the SS, which was that the inmates were racial inferiors to be treated only with contempt. There is evidence that where manpower considerations permitted, Himmler wanted to rotate guard battalions so that all members of the SS would be instructed as to the proper attitude to take to inferior races. After 1942, when the concentration camps were placed under the control of the WVHA, they were used as a source of slave labor. An agreement made with the Ministry of Justice on the 18th of September 1942 provided that antisocial elements who had finished prison sentences were to be delivered to the SS to be worked to death. Steps were continually taken involving the use of the security police and SD and even the Waffen-SS to ensure that the SS had an adequate supply of concentration camp labor for its projects. In connection with the administration of the concentration camps, the SS embarked on a series of experiments on human beings which were performed on prisoners of war or concentration camp inmates. These experiments included freezing to death and killing by poison bullets. The SS was able to obtain an allocation of government funds for this kind of research on the grounds that they had access to human material not available to other agencies. The SS played a particularly significant role in the persecution of the Jews. The SS was directly involved in the demonstrations of November the 10th, 1938. The evacuation of the Jews from occupied territories was carried out under the directions of the SS with the assistance of SS police units. The extermination of the Jews was carried out under the direction of the SS central organizations. It was actually put into effect by SS formations. The Einsatzgruppen engaged in wholesale massacres of the Jews. SS police units were also involved. For example, the massacre of Jews in the Warsaw Ghetto was carried out under the directions of SS Brigade Führer and Major General of the Police, Stroop. A special group from the SS Central Organization arranged for the deportation of Jews from various Axis satellites, and their extermination was carried out in the concentration camps run by the WVHA. It is impossible to single out any portion of the SS which was not involved in these criminal activities. The Allgemeine SS was an active participant in the persecution of the Jews and was used as a source of concentration camp guards. Units of the Waffen-SS were directly involved in the killing of prisoners of war and the atrocities in occupied countries. It supplied personnel for the Einsatzgruppen and had command over the concentration camp guards after its absorption of the Totenkopf SS, which originally controlled the system. Various SS police units were also widely used in the atrocities in occupied countries and the extermination of the Jews there. The SS Central Organization supervised the activities of these various formations and was responsible for such special projects as the human experiments and final solution of the Jewish question. The Tribunal finds that knowledge of these criminal activities was sufficiently general to justify declaring that the SS was a criminal organization to the extent hereinafter described. It does appear that an attempt was made to keep secret some phases of its activities, but its criminal programs were so widespread and involved slaughter on such a gigantic scale that its criminal activities must have been widely known. It must be recognized, moreover, that the criminal activities of the SS followed quite logically from the principles on which it was organized. Every effort had been made to make the SS a highly disciplined organization composed of the elite of National Socialism. Himmler had stated that there were people in Germany who become sick when they see these black coats, and that he did not expect that they should be loved by too many. Himmler also indicated his view that the SS was concerned with perpetuating the elite racial stock with the object of making Europe a Germanic continent, and the SS was instructed that it was designed to assist the Nazi government in the ultimate domination of Europe and the elimination of all inferior races. This mystic and fanatical belief in the superiority of the Nordic German developed into the studied contempt and even hatred of other races, which led to criminal activities of the type outlined above, being considered as a matter of course, if not a matter of pride. The actions of a soldier in the Waffen-SS, who in September 1939, acting entirely on his own initiative, killed 50 Jewish laborers whom he had been guarding, were described by the statement, that as an SS man, he was particularly sensitive to the sight of Jews and had acted quite thoughtlessly in a youthful spirit of adventure, and a sentence of 3 years' imprisonment imposed on him was dropped under an amnesty. Hess wrote with truth that the Waffen-SS were more suitable for the specific tasks to be solved in occupied territory owing to their extensive training in questions of race and nationality. Himmler, in a series of speeches made in 1943, indicate his pride in the ability of the SS to carry out these criminal acts. He encouraged his men to be tough and ruthless. He spoke of shooting thousands of leading Poles and thanked them for their cooperation and lack of squeamishness at the sight of hundreds and thousands of corpses of their victims. He extolled ruthlessness in exterminating the Jewish race and later described this process as delousing. These speeches show that the general attitude prevailing the SS was consistent with these criminal acts. Conclusions. The SS was utilized for purposes which were criminal under the Charter, involving the persecution and extermination of the Jews, brutalities and killings in concentration camps, excesses in the administration of occupied territories, the administration of the slave labor program, and the mistreatment and murder of prisoners of war. The defendant Kaltenbrunner was a member of the SS implicated in these activities. In dealing with the SS, the tribunal includes all persons who had been officially accepted as members of the SS, including the members of the Allgemeine SS, members of the Waffen-SS, members of the SS Totenkopfverbände, and the members of any of the different police forces who were members of the SS. The tribunal does not include the so-called SS riding units. The Sicherheitsdienst des Reichsführer SS, commonly known as the SD, is dealt with in the tribunal's judgment on the Gestapo and SD. The tribunal declares to be criminal within the meaning of the Charter the group composed of those persons who had been officially accepted as members of the SS as enumerated in the preceding paragraph, who became or remained members of the organization with knowledge that it was being used for the commission of acts declared criminal by Article 6 of the Charter, or who were personally implicated as members of the organization in the commission of such crimes, excluding, however, those who were drafted into membership by the state in such a way as to give them no choice in the matter, and who had committed no such crimes. The basis of this finding is the participation of the organization in war crimes and crimes against humanity connected with the war. This group, declared criminal, cannot include, therefore, persons who had ceased to belong to the organizations enumerated in the preceding paragraph prior to September the 1st, 1939. The SA. Structure and component parts. The prosecution has named die Sturmabteilungen der Nationalsozialistischen Deutschen Arbeiterpartei, commonly known as the SA, as an organization which should be declared criminal. The SA was founded in 1921 for political purposes. It was organized on military lines. Its members wore their own uniforms and had their own discipline and regulations. After the Nazis had obtained power, the SA greatly increased in membership due to the incorporation within it of certain veterans' organizations. In April 1933, the Stahlhelm, an organization of 1.5 million members, was transferred into the SA, with the exception of its members over 45 years of age and some others, pursuant to an agreement between their leader, Seldter, and Hitler. Another veterans organization, the so-called Kaifhauserbund, was transferred in the same manner, together with a number of rural riding organizations. Until 1933, there is no question but that membership in the SA was voluntary. After 1933, civil servants were under certain political and economic pressure to join the SA. Members of the Stahlhelm, the Kaifhuserbahn, and the rural riding associations were transferred into the SA without their knowledge. But the tribunal is not satisfied that the members in general endeavored to protest against this transfer, or that there was any evidence, except in isolated cases, of the consequences of refusal. The tribunal therefore finds that membership in the SA was generally voluntary. By the end of 1933, the SA was composed of 4.5 million men. As a result of changes made after 1934, in 1939, the SA numbered 1.5 million men. Activities. In the early days of the Nazi movement, the stormtroopers of the SA acted as the strong arm of the party. They took part in the beer hall feuds and were used for street fighting in battles against political opponents. The SA was also used to disseminate Nazi ideology and propaganda, and placed particular emphasis on anti-Semitic propaganda, the doctrine of Lebensraum, the revision of the Versailles Treaty, and the return of Germany's colonies. After the Nazi advent to power, and particularly after the elections of March the 5th, 1933, the SA played an important role in establishing a Nazi reign of terror over Germany. The SA was involved in outbreaks of violence against the Jews and was used to arrest political opponents and to guard concentration camps where they subjected their prisoners to brutal mistreatment. On June the 30th and July the 1st and 2nd, 1934, a purge of SA leaders occurred. The pretext which was given for this purge, which involved the killing of Röhm, the chief of staff of the SA, and many other SA leaders, was the existence of a plot against Hitler. This purge resulted in a great reduction in the influence and power of the SA. After 1934, it rapidly declined in political significance. After 1934, the SA engaged in certain forms of military or paramilitary training. The SA continued to engage in the dissemination of Nazi propaganda. Isolated units of the SA were even involved in the steps leading up to aggressive war, and in the commission of war crimes and crimes against humanity. SA units were among the first in the occupation of Austria in March 1938. The SA supplied many of the men and a large part of the equipment which composed the Sudeten Free Corps of Henlein, although it appears that the Corps was under the jurisdiction of SS during its operation in Czechoslovakia. After the occupation of Poland, the SA group's Sudeten was used for transporting prisoners of war. Units of the SA were employed in the guarding of prisoners in Danzig, Posen, Silesia, and the Baltic states. Some SA units were used to blow up synagogues in the Jewish pogrom of the 10th and 11th of November 1938. Groups of the SA were concerned in the ill treatment of Jews in the ghettos of Vilna and Kaunas. Conclusion. Until the purge, beginning on June the 30th, 1934, the SA was a group composed in large part of ruffians and bullies who participated in the Nazi outrages of that period. It has not been shown, however, that these atrocities were part of a specific plan to wage aggressive war, and the tribunal therefore cannot hold that these activities were criminal under the Charter. After the purge, the SA was reduced to the status of a group of unimportant Nazi hangers-on. Although in specific instances some units of the SA were used for the commission of war crimes and crimes against humanity, it cannot be said that its members generally participated in or even knew of the criminal acts. For these reasons, the tribunal does not declare the SA to be a criminal organization within the meaning of Article 9 of the Charter. Give me your pen, will you? The Reich Cabinet. The prosecution has named as a criminal organization the Reich Cabinet, die Reichsregierung, consisting of members of the ordinary cabinet after January the 30th, 1933, members of the Council of Ministers for the Defense of the Reich, and members of the Secret Cabinet Council. The tribunal is of opinion that no declaration of criminality should be made with respect to the Reich Cabinet for two reasons. One, because it is not shown that after 1937 it ever really acted as a group or organization. Second, because the group of persons here charged is so small that members could be conveniently tried in proper cases without resort to a declaration that the cabinet of which they were members was criminal. As to the first reason for our decision, it is to be observed that from the time that it can be said that a conspiracy to make aggressive war existed, the Reich Cabinet did not constitute a governing body, but was merely an aggregation of administrative officers subject to the absolute control of Hitler. Not a single meeting of the Reich Cabinet was held after 1937, but laws were promulgated in the name of one or more of the cabinet members. The Secret Cabinet Council never met at all. A number of the cabinet members were undoubtedly involved in the conspiracy to make aggressive war, but they were involved as individuals, and there is no evidence that the cabinet as a group or organization took any part in these crimes. It will be remembered that when Hitler disclosed his aims of criminal aggression at the Hossbach Conference, the disclosure was not made before the cabinet, and that the cabinet was not consulted with regard to it. But on the contrary, it was made secretly to a small group upon whom Hitler would necessarily rely in carrying on the war. Likewise, no cabinet order authorized the invasion of Poland. On the contrary, the defendant Schacht testifies that he sought to stop the invasion by a plea to the commander-in-chief of the army that Hitler's order was in violation of the Constitution because not authorized by the cabinet. It does appear, however, that various laws authorizing acts which were criminal under the Charter were circulated among the members of the Reich Cabinet and issued under its authority, signed by the members whose departments were concerned. This does not, however, prove that the Reich Cabinet after 1937 ever really acted as an organization. As to the second reason, it is clear that those members of the Reich Cabinet who have been guilty of crimes should be brought to trial, and a number of them are now on trial before the tribunal. It is estimated that there are 48 members of the group, that 8 of these are dead and 17 are now on trial, leaving only 23 at the most, as to whom the declaration could have any importance. Any others who are guilty should also be brought to trial, but nothing would be accomplished to expedite or facilitate their trials by declaring the Reich Cabinet to be a criminal organization. Where an organization with a large membership is used for such purposes, a declaration obviates the necessity of inquiring as to its criminal character in the later trial of members who are accused of participating through membership in its criminal purposes, and thus saves much time and trouble. There is no such advantage in the case of a small group like the Reich Cabinet. General Staff and High Command. The prosecution has also asked that the General Staff and High Command of the German Armed Forces be declared a criminal organization. The tribunal believes that no declaration of criminality should be made with respect to the General Staff and High Command. The number of persons charged, while larger than that of the Reich Cabinet, is still so small that individual trials of these officers would accomplish the purpose here sought better than a declaration such as is requested. But a more compelling reason is that in the opinion of the tribunal, the General Staff and High Command is neither an organization nor a group within the meaning of those terms as used in Article 9 of the Charter. Some comment on the nature of this alleged group is requisite. According to the indictment and evidence before the tribunal, it consists of approximately 130 officers, living and dead, who at any time during the period from February 1938, when Hitler reorganized the armed forces, and May 1945, when Germany surrendered, held certain positions in the military hierarchy. These men were high-ranking officers in the three armed services: OKH, Army, OKM, Navy, and OKL, Air Force. Above them was the overall Armed Forces Authority, OKW, High Command of the German Armed Forces, with Hitler as the Supreme Commander. The officers in OKW, including the defendant Keitel as Chief of the High Command, were in a sense Hitler's personal staff. In the larger sense, they coordinated and directed the three services, with particular emphasis on the functions of planning and operations. The individual officers in this alleged group were, at one time or another, in one of four categories. First, Commanders-in-Chief of one of the three services. Second, Chief of Staff of one of the three services. Third, Oberbefehlshabers, the Field Commanders-in-Chief of one of the three services, which of course comprised by far the largest number of these persons. Or four, an OKW officer, of which there were three, defendants Keitel and Jodl, and the latter's deputy chief, Warlimont. This is the meaning of the indictment in its use of the term General Staff and High Command. The prosecution has here drawn the line. The prosecution does not indict the next level of the military hierarchy, consisting of commanders of Army Corps and equivalent ranks in the Navy and Air Force, nor the level below, the divisional commanders or their equivalent in the other branches. And the staff officers of the four staff commands of OKW, OKH, OKM, and OKL are not included, nor are the trained specialists who were customarily called General Staff Officers. In effect, then, those indicted as members are military leaders of the Reich of the highest rank. No serious effort was made to assert that they composed an organization in the sense of Article 9. The assertion is rather that they were a group, which is a wider and more embracing term than organization. The tribunal does not so find. According to the evidence, they are planning at staff level the constant conferences between staff officers and field commanders, their operational technique in the field and at headquarters was much the same as that of the armies, navies, and air forces of all other countries. The overall effort of OKW at coordination and direction could be matched by a similar, though not identical, form of organization in other military forces, such as the Anglo-American Combined Chiefs of Staff. To derive from this pattern of their activities the existence of an association or group does not, in the opinion of the tribunal, logically follow. On such a theory, the top commanders of every other nation are just such an association, rather than what they actually are, an aggregation of military men, a number of individuals who happen at a given period of time to hold the high-ranking military positions. Much of the evidence and the argument has centered around the question of whether the membership in these organizations was or was not voluntary. In this case, it seems to the tribunal to be quite beside the point. For this alleged criminal organization has one characteristic, a controlling one, which sharply distinguishes it from the other five indicted. When an individual became a member of the SS, for instance, he did so, voluntarily or otherwise, but certainly with the knowledge that he was joining something. In the case of the General Staff and High Command, however, he could not know he was joining a group or organization, for such organization did not exist, except in the charge of the indictment. He knew only that he had achieved a certain high rank in one of the three services, and could not be conscious of the fact that he was becoming a member of anything so tangible as a group, as that word is commonly used. His relations with his brother officers in his own branch of the service and his association with those of the other two branches were in general like those of other services all over the world. The Tribunal therefore does not declare the General Staff and High Command to be a criminal organization. Although the Tribunal is of the opinion that the term group in Article 9 must mean something more than this collection of military officers, it has heard much evidence as to the participation of these officers in planning and waging aggressive war and in committing war crimes and crimes against humanity. This evidence is, as to many of them, clear and convincing. They have been responsible, in large measure, for the miseries and suffering that have fallen on millions of men, women, and children. They have been a disgrace to the honorable profession of arms. Without their military guidance, the aggressive ambitions of Hitler and his fellow Nazis would have been academic and sterile. Although they were not a group falling within the words of the Charter, they were certainly a ruthless military caste. The contemporary German militarism flourished briefly with its recent ally, National Socialism, as well as, or better than it had in the generations of the past. Many of these men have made a mockery of the soldier's oath of obedience to military orders. When it suits their defense, they say they had to obey. When confronted with Hitler's brutal crimes, which are shown to have been within their general knowledge, they say they disobeyed. The truth is, they actively participated in all these crimes, or sat silent and acquiescent, witnessing the commission of crimes on a scale larger and more shocking than the world has ever had the misfortune to know. This must be said. Where the facts warrant it, these men should be brought to trial, so that those among them who are guilty of these crimes should not escape punishment. The Tribunal will sit tomorrow at 9:30 a.m. The Tribunal will now adjourn.